Hi, this is Ishita Dutta, a legal intern at LEXIS and Company, and today I will be talking about the basic facts one should know about a partition deed. So, what is a partition deed? Joint ownership of a property by many people is quite common, especially if it is an immovable estate that is owned by a family. So, the need for partition arises when the co-owners decide to go their own way, as the combined ownership over the property limits their rights. So the legal instrument that is used to effect this change is known as the deed of partition or partition deed in legal parlance. A partition deed is mostly used by families to divide members' share in inherited properties. So after the division, each member becomes the independent owner of his share in the property and is legally free to sell, rent or gift his asset according to his will. So when do you need a partition deed? To answer this, co-owners enjoy limited rights over a property as their undivided shares leave a lot of scope for uncertainty. Even though all these people are joint owners, they are not free to rent, sell or gift the property on their own accord unless each party agrees to such a proposition. Basically, the consent of each co-owner is required to carry out such transaction. The need for a partition deed arises when it becomes important to create a clear division of shares in the property. So how is property divided under a partition deed? So the answer to this is, if a property is being divided between two people who have invested in the purchase, the division is based on their respective contribution. For example, if two siblings bought a property for say 1 crore and each contributed 50 lakhs, the property will be divided equally between the two parties through a partition deed. If the ratio of their contribution is 60-40, the division would be in this manner. So, however, the law assumes each member to have an equal share in an undivided property unless documentary proof stating otherwise is produced. So, in the case of an inherited property, co-owners would get their share in a property based on their treatment in the inheritance law governing their religion. So, what is the application of inheritance law on deed partition? So partition of any property is subject to the laws of inheritance. This brings into picture inheritance law governing property division among Hindus, Muslims and Christians. So at the time of partition, the share of each member is determined based on his entitlement under the applicable inheritance laws. So in the case of Hindus, the provisions of the Hindu Succession Act 1956 will be applicable at the time of partition of an inherited state. The next question is, what happens to a property after a partition deed is executed? So once the partition deed comes into an effect, each share in the property becomes an independent entity. So each divided share of the asset gets a new title. Also, members surrender their claim in the shares that have been allocated to the other members. For example, if Ram, Sham and Mohan divide a property through a partition deed, so then Ram and Sham would give up their right in the part that has been allocated to Mohan. Similarly, Mohan would also give up his right in the shares allocated to Ram and Sham. Apart from the common areas where easements rights are applicable, each one has an independent property within an estate after its partition. This also provides them the right to deal with their share in a manner they like. So after the partition, each party must also complete the property mutation process to make the change legally valid. So the registration and stamp duty on partition deed. So to attain a validity, a legal validity, a partition deed must be registered with the sub-registrar of the area in which the immovable asset is located. This is mandatory under Section 13 of the Indian Registration Act of 1908. This means that the parties involved in the partition will have to pay stamp duty charges under the provisions of the Indian Stamp Act 1899 and the registration charge to get the partition deed registered. For example, in Delhi, 2% of the value of the separated share of the property has to be paid as the stamp duty on a partition deed. The same rate is applicable on registration of the partition deeds in Maharashtra along with 1% registration charge. However, it is not mandatory for the co-owners to register the partition deed in the state. So the manner of calculation of stamp duty would be better explained through an example. So suppose a father through partition divides his estate worth 5 crores into 3 parts, keeping 40% of the share with himself while allocating 30% each to 2 of his sons. So in this case, the stamp duty will be applicable on the 60% of the property value, which is 3 crores. Supposing this property is located in Delhi and the applicable stamp duty levy is 2%, then the brothers will have to pay 6 lakhs to register the partition deed. So the question comes about it, is it compulsory to register a partition deed? So in 2018, the Maharashtra government said that the process of partition of properties belonging to a Hindu undivided family and the receipt thereof by a corporationer do not fall under the definition of transfer. Consequently, it is not compulsory to register such partition deeds. Note here that in the case the partition has been effected through a partition deed, which has not been registered, the deed will not be admissible as a proof in a court of law. So what is the difference between partition deed and partition suit? To answer to this question, I would like to say that under the provisions of the law, a property would be divided either by way of a partition deed or by a partition suit. The need to go for the second option arises in cases of a dispute or in cases where the co-owners do not mutually agree to the partition. So in this case, a partition suit must be filed in an appropriate court of law. So before one can file a suit, they will have an issue to request to all the co-owners demanding partition. So in this case, the party refuses to entertain a request, you are within your legal rights to move the court over the matter. Under the Indian laws, the aggrieved party must approach the court within 3 years from the date when the right to file a partition suit accrues. Both the instruments, however, serve the same purpose, but they create and extinguish rights of co-owners in a jointly owned property. So the words of caution would be that the text of the partition deed must be such that it explicitly mentions each aspect of the division. Aside from the names of the party concerned, the deed must have a clear mention of the date on which the partition is effected. So in a case there are any ambiguities in the language or any errors in the text, a partition deed could be challenged in the court of law. So co-owners are advised thus to first reach an agreement and clearly set the terms and conditions of the partition. All aspects of the division must be considered by each party so as to avoid any inconvenience in the future. Once the partition deed document is prepared, all the parties concerned must read it thoroughly to ensure that there are no ambiguities and that it is error-free. Once the text is final, the deed must be drafted on a stamp paper and the parties involved must proceed with the registration. So the treatment of verbal partition or family settlement. So under the laws governing inheritance amongst Hindu, Jains, Buddhists and Sikhs, class 1 heirs of property can enter into a verbal memorandum of family settlement and divide the property on mutually agreeable terms. Since this oral agreement has been reached without using the partition deed as an instrument, the need to register the transaction is entirely avoided. So while delivering its verdict in the case of Nitin Jain versus Anju Jain and others, a division bench of the Delhi High Court in 2007 ruled that no stamp duty is payable in case of a verbal division of property. It is legally permissible to arrive at an oral family settlement, dividing or partitioning the properties and thereafter record a memorandum in writing, whereby the existing joint owners for the sake of posterity record that the property has been already partitioned or divided, the bench held. Courts have recognized oral partitions in cases of joint families. An oral partition is not an instrument of partition as contemplated under Section 21 as Section 2 Clause 15 of the Stamp Act. Therefore, as it is not an instrument, no stamp duty is payable on an oral partition, the High Court further said. However, in the absence of partition deed, the shares of the co-owners remain undivided in this kind of arrangement, and this also means that they are not free to sell, gift or transfer their share in their property on their own. So what is the income tax on the partition deed? So since there are no transfer has taken place as such through the partition, the beneficiaries are not liable to pay any capital gains tax after the division. Thank you so much.